Thank you. Welcome, everybody, to House General and Housing. It is February 26th. February is speeding by. Today, we're going to focus first on H772, which is the landlord tenant bill. We've been walking through changes to the bill. We walked through entirely yesterday the bill, but there were changes that need to be made, and we have counsel with us. And we're going to have a walkthrough, discussion, and a potential vote on 772. And then if 772, if the committee in its wisdom decides that it is passing 772 in some form out of this committee, it will go to appropriations. I think it will also be looked at in some way by judiciary. So we have our esteemed counsel back with us. And would you like to take it away, Cameron?
Sure. Good morning.
Good morning.
Cameron Wood, Office of Legislative Counsel. I have a new draft 2.1, your amendment to H772. And I shared it just moments ago with Miriam. So I presume at this point it has made its way onto your webpage.
Miriam, is it posted yet?
Fortunately for you, you have me here to share this.
It is very fortunate.
Okay,
Thank you.
so draft 2.1. As I mentioned yesterday, this has not been edited or would not be edited by 9 o'clock this morning. So I do have a watermark on here just indicating that. Okay. It's highlighting that for you all before you vote. I would need to send this off and have at least the new sections reviewed. I have highlighted the changes yellow. I removed all the highlights from the previous version, the things that had been discussed. I know there were still a few points for discussion, but I removed those highlights so this would at least indicate for you all to follow along more easily what has changed in this version. So we're in section 1, amending chapter 137, residential rental agreements in the definitions section. I'm moving to page 2. In the subdivision 5, I did a little cleanup that was pointed out by Rep. Parsons to state that if the last address is unknown, then it's posted on the door. And then the only other addition here is in the sub B to add the posting on the door under the rebuttable presumption. So the rebuttable presumption is the notice is received after 5 days of the date the email is sent, the date of posting on the door, the date of mailing. The landlord is still going to need to prove in some capacity that they posted it on the door, but assuming they can prove that, then there will be a presumption of receipt 5 days after that.
We don't want to spell that out.
What?
What constitutes proof of having posted it? What would normally happen?
I would expect, you can if you want, but
They would
Is there a normal procedure that you know of?
take a picture.
Okay.
okay. So that is the first change.
I will say the practical matter, and Debbie, correct me, since you're our resident expert on this, if I'm wrong, as a practical matter, landlords are very concerned that the notice be real. That, notice is important to landlords. So they make an effort to make sure that they do everything they need to do to nail it down. And if they post, my assumption is if they post it because there's no address, they'll take a picture or something to show they posted it.
They're important to the tenant.
As well, right? Yep. Okay.
Okay. The next change is going to be on the next page, page 3. This is related to the prohibition on increasing rent more than once in a 12-month period. And I've drafted that this subsection shall not prohibit a landlord from increasing rent after the purchase of a dwelling unit subject to the requirements of this section.
Right, so this is the change, remember, that we had for people who are purchasing the building is different than perpetually owning it, remember?
We're still doing that?
No, I'm saying that if you purchase a new building,
You can
you're
offer
carved
rent.
out of the requirement.
If you purchase the building, as mentioned, you can then raise the rent regardless of when the rent was raised previously. And then at that point, you wouldn't be able to raise it again. for a
Right.
12-month period.
Okay,
Okay. The next change is going to be at the bottom of this section where we're talking about the residential rental application and the definition of what is the application and the carve out for the credit report and the background check. So I tweaked the language slightly to just say here on beginning lines 19. Unless the tenant, so the landlord can charge the actual cost unless the tenant or applicant provides a current credit report. It said credit check, so a current credit report as part of the application. So we've added the word current. And then I've added the language moving to the top of page 4 for the purposes of this subdivision. A current credit report means a report dated within 90 days prior to the date of the residential rental application.
I think that this goes against our whole, like, there's no application fees that is. I think that there's going to be some sort of, yeah, I'm not comfortable with that language, just because from speaking to the Attorney General's office, that like, there's not clarity about the fees, what people out in the field are telling people that like applicants that complain to the AG or to Vermont Legal Aid. It's stated like, no, you can't be charging application fees, period. That includes credit checks, background checks.
yes, so
Unless we change it here.
My question would just be, has it ever been ruled upon whether that, because that's been the whole problem, which is like this.
right.
They created the law, then people said,
Right.
that's not, I'm not charging a fee to submit it, I'm charging you a fee after we
Right.
move forward, and now we're stuck with this process. And then legal aid had said, well, we don't read it that way, and like, said, well, we do. Has anyone ever made that?
There's no case on point.
Nobody is sued based on it.
No.
Not that I'm aware
Somebody's
of.
ever like
because
won
I
a
don't-
case either way on it?
I don't know what the remedy would be. You, I guess, a resident could sue the landlord for damages of having to pay the cost of the credit check. And I don't imagine anyone's going through that process. I haven't seen court make that determination.
No, the AG said that basically they'll call the landlord and just say, hey, there's this, like, they'll just do
Who
a
said that?
informal,
Right.
the
The
AG,
attorney.
The office or the Attorney General?
Yeah,
the office.
yes,
If we really want to know, we would have, I'm not recommending we do it right this second, but a realtor or rental agent would be better able to tell you if a fee to apply to live somewhere used to be a device to,
separate it.
well, it was to manipulate the clientele.
Yeah,
So it
sure.
was a higher class rent.
Yeah, right, yeah.
Kind of, and that's the fee that's prohibited.
I guess my own view on this
If
is.
we clarify it,
Right. We did. My own view is there are two issues here. One is the language clearer than the language was, and the other is a policy question that Lenore is raising. In my view on the clarity, it couldn't be clearer than it is now, much more than it was, in the sense that you can't charge any fee except a credit and background check, period. It's easy to say, it's easy to explain.
Yeah.
There it is. And in fact, I think from the legal point of view, which my own view, from a legal point of view, it's better than it was, because by putting that you can do this, by implication, you can't do anything else. However, there's the policy question, which I think you're raising, which is, who should pay for the credit check? And I think one argument is the tenant should pay for it. and the other, the background check, and the other is the landlord. And that's a policy decision. This draft makes the policy decision in favor of the landlord being able to charge for that. And thus that the tenant pays it. You know, that's a pure policy decision.
I think if we defined current more clearly, then it would make more sense, right? Because then it would be like the applicant doesn't
Have to do repeated. Well, the 90-day idea was,
Where is that?
The clarification.
at the last, the second sentence. The 90 days, remember, was to, in order to avoid
Right, having to.
having to
if
do
you're-
repeated,
right,
repeated.
Elizabeth,
Like you've
Raise
been
your
given
hand.
notice that you've got 60 or 90 days to leave your place, you're gonna start applying for like
Right,
5 or 6 apartments. Do you need to suddenly pay like
each time.
$600 in
Right.
application?
And I had also talked to the banker guy about if that
Oh, yeah,
would
the
ding the
soft-
credit. And he said,
You mean, Chris?
That's all.
yeah, soft balls.
Yeah, they're softball, but, yes, Elizabeth.
Thank you. My question for the landlords in the room is there a stepped process for applying to live in a residence? Like, is the credit check at the initial step or is it at a final step?
I bet it
Thanks.
depends on the person.
Mm,
You guys, I mean, I would imagine a landlord, let's say a landlord gets 25 applications. I don't know that they would bother to ask for credit checks from everybody. They're gonna, look at them and sort of pick top 3 or
Yeah.
something and ask for credit back checks. But I don't know. Debbie, what do you think? I actually am sorry if I'm calling on you
I know we
unnecessarily.
do have other landlords in the room, but.
Are you a landlord?
maybe.
Yeah.
Anyhow,
It's true, it's
well, I
Chris.
do know
Chris,
what we do.
Yeah.
We need to talk to the person first to find out if they do know where St. John's Ferry, Vermont is.
Okay,
Because sometimes
Sure.
you know, even how far away we are, even though you may be in Vermont,
Yeah,
you know, we're 2.5 hours from where you're living right now. So if your job is at that location, you may not want to have that commute time. You know, we just doing like a little clearing.
yeah,
You
yeah.
know. And also, you know, who's gonna be living there, you know, kind of thing. It's like, oh.
Like a little pre-screen.
A little pre-screen,
Yeah.
basically. Yeah, that's what we do first, but
Makes sense.
Chris,
personally, we do our own background credit check.
And
Chris,
What do you mean? Well,
My-
we get a list of previous landlords, we get a list of where they work, we call their employers, we call people that know them.
But you
Rather
don't
than
have any
paying.
legal background, or you don't know
We
anything
don't
about their,
personally, but I know other
creditworthiness.
landlords that
Yeah.
do.
you don't know their credit worthiness, and you
No.
don't know anything about their legal, whether they have any felonies or anything like that.
We ask them if they have felonies.
Well, ask me.
uh,
No,
Chris, you want to identify yourself?
Chris Donnelly, Champlain Housing Trust.
Do you have anything to add to the answer to Elizabeth's question?
We have a pre-application before a full application. We do credit and background checks. We do not charge the tenant.
Okay, but do you do them on everybody in the pre-application or? No, so you have, you narrow it and then you do it. Okay.
Okay.
And-
Go ahead, Elizabeth, sorry.
I guess part of my my understanding is that there is a first phase and that the background and credit check are part of kind of a, as Debbie was saying, that next step is kind of like a, you know, looking at references. We're getting more serious now kind of step. And I guess my point actually is that in that delineation, it's easy to separate out the credit check from any kind of application fee.
Right. Tom?
I'm content with this language because we've made it clear that it's at cost. We've taken away the incentive to require all 25 applicants to do it because we're making $20 a head on it. So that's taken out. There's really no incentive to ask for it unless you're serious.
I agree.
And I think maybe just something that would say like, and the landlord has to provide the, you know,
And
if
invoices.
if it's pulled, they have to give a copy to the tenant.
Yeah, I think the tenant should be able to review that, certainly. We did make it a little more difficult to do background checks in the last session by. just-
Right, because of the social security number, right? Yeah.
So we made it.
Unless the person runs their
They might
own,
just
yeah.
say, yeah, it's, you know, it's at their discretion. But I think that, weighing against changes we made in the last session, I'm okay with this.
Yeah, can we, is it okay? Yeah, maybe when if there's more time. I'll swear we don't want to make any more language changes. I get that, but
Okay,
if we're
all right.
talking about possible language changes, I would add just a stipulation that when you charge for one, you have to give the copy, you have to give it to the tenant.
That makes sense.
So it'd be something like, and present the tenant with,
With the background check, with a copy
Yeah.
of the report.
Goodness knows they're all.
Okay, you got that?
Would you like that included?
Yes, yeah, okay, yes.
And so if that were to fall through and the next landlord didn't want to accept it.
Then 90 days, they have to for 90 days.
Right, okay.
Right,
Yeah.
yeah. Okay, go ahead, council.
I'm happy.
So
with
we're changing that way.
Okay, we're on page 3.
it. Awesome.
All right.
Okay. I am moving to the next change, which is going to be on page 5. This is regarding security deposits. If you recall, there was the section where if the landlord terminates the tenancy under the 4467D or E. So the landlord is kind of the one primarily initiating the termination, not because of some sort of fault of the tenant. Then
I see, yeah.
at the request of the tenant, the landlord shall return 1/2 of the security deposit along with a written statement itemizing the deductions no later than 45 days. It was 60 days on to 45, included at the request of the tenant.
Okay,
The next section is going to be the bottom of.
you want to say anything? Yeah. Not now. Okay, all right.
No, I mean,
We'll have discussion.
yes.
And we can come back to this. Okay, all right, I'm with you.
Okay.
I have not forgotten.
Okay, bottom of page 5, top of page 6, I've added in this entire section about retaliatory conduct, it's current statute, but it's new section in the bill. Because I've added in this subdivision 4 here on page 6. So as we talked yesterday, the landlord cannot retaliate against a tenant by changing the terms or threatening to bring an action if the tenant is exercising their rights under the chapter, if they've made some sort of complaint to the
Right.
landlord about the habitability or complaint to a government entity. So I've added in here, or the tenant has taken any legal action against the landlord authorized by law.
By the way, since we just mentioned, we just went over something where what we want to try to focus on the walkthrough is it doesn't mean we can't raise issues that during the walkthrough as opposed to discussion, if they are amenable to like small change, changes in the text. I mean, if your feeling is, I just don't like this whole idea.
right,
That's the time for that is when we discuss it. But if your feeling is like just happened a minute ago, I'm okay with this. If we add this provision, then this is the time to say that. You see what I mean? In other words, when we got the guy here and we can make language.
but keep track as we go along
Yeah,
for the discussion.
right. Okay,
Debbie's checking it off.
all right. Okay, go ahead.
Questions about this or?
No.
Okay, we keep moving this. I'm going to move to page 8. We're moving into the section about termination of tenancy. And I highlighted this not because it's a change, but because it was discussion about whether to change it. So I'm happy to move over this if you all want to reserve that for conversation. This is where you've added in the landlord may terminate for repeated late payment of rent, and then it's defined as payments more than 10 days after it's due. So you all can reserve that for your discussion, but it was one that I had circled.
Okay.
It seemed like there was possible.
Right. I'm just putting a pin on something. Earlier, we changed notice. Remember the notice provisions right in the beginning? And I'm responsible for this, and I could be wrong. I mean, I just want to say it. It used to say that notice was effective presumed to have occurred after 3 days, and I changed it to 5. I just want to say my simple reason for doing that is just what's been going on with the mail in Vermont, and the fact that our postal service is getting worse and worse. There's no magic behind that. I just wanted to say that. Okay, go on.
I appreciate that.
So the next change, I'm going to move all the way down to page 11. So these are all the changes that we've made in relation to the termination notices. And for what reasonings? Mr. Chair, I'm going to pause because Director Burrows has her hand up.
Good thing someone's looking at that.
It's actually giving.
How can you see that?
I didn't, usually I'm
It's
trying.
good your back is turned.
Oh, that's good. That's helpful.
I'm seeing it like right when it happens.
Hey, Elizabeth, you're on.
Thanks. My question is, for mail, the mail requirement,
Right.
and really it addresses your expansion of the time from 3 to 5 days. Does the mail requirement include a receipt?
You only receive the rebuttable presumption if you send it via first class or certified US mail.
So
So
when we send via certified or first class mail, do we still have to sign off on it?
If you pay for a return
Right.
receipt, that's an extra add-on, and you probably will not get one.
Right, you can ask for that type of thing, but it's not always, if that makes sense.
So my
Um,
my suggestion might be that we require a receipt, a proof of receipt, instead of having a date certain 3 or 5 days, and then that would actually take away whatever constraints there are by the postal delivery service, because there's proof of the recipient having received it.
Thank you. We have a number of comments. Tom, let's going to start with you because you said a minute ago that you wouldn't get the return receipt.
All they have to do is not sign for it. Again, and they cannot sign for it indefinitely.
Okay. Debbie, did you want, no,
No,
I guess Joe was next.
Yeah, I think Tom's point rolls back into the same whole point of why tack orders are given. It's because, I mean, you're saying we're giving, sort of looking for, I don't know what it is, but, we're giving sheriffs and the postal office the benefit of the doubt, basically saying like they tried
yeah,
and nothing, not reaching the person, and we're giving them that benefit of the doubt.
Right.
I know, yeah.
So I think the whole point is, that goes against kind of the entire point of having to be first class certified mail or.
Debbie, did you want to add anything?
Well, I just want to tell people that if you send it certified, which I think costs $5.10, the price might have gone up. But you get tracking with that. So you can track it and you can say it, like you'll say it was delivered. Yeah, you can track it. So I agree with Tom in the return receipt.
Yeah.
No, nobody signs those things. Plus that takes like 30 days for that whole process to happen. And it's like, we're not waiting 30 days.
I'm not
to get the
comfortable.
card back.
I guess my feeling is if there were a device, I would be interested, but apparently there isn't.
I'm not comfortable with adding it, just it's become more burdensome.
All right, so in this draft, it's staying this way. Let's go to your next change.
Okay. As I mentioned, the next change is gonna be on page 11. This is related to week rental agreements. This is just making it consistent with the period that you have above for non-payment of rent at 10 days. So I struck the section, the language that says, however, a notice to terminate for non-payment of rent shall be as provided in section A, so consistent.
Anybody have,
No.
Okay.
Good.
The next change is gonna be on page 13. This is the time frame that a landlord has to bring an ejectment action after a termination notice has been provided. And if you recall, there was a breakout to have it as 30 days if it was for non-payment of rent or for breach of the rental agreement, and 60 days otherwise. And you all discussed just going back to 60 days. There's nothing requiring a landlord to wait 60 days. The landlord can bring it at whatever time the landlord so chooses. This just says that if you do not bring it within 60 days, then you can't use that termination notice for the tenant. Okay. The next section is the affirmative defense section. This is where the tenant has the right to this defense and judgment is issued if there exists a serious health and safety code violation issued to the landlord. And I made the change to state, and the landlord has made no reasonable attempt to correct the violation. Previously, it said the violation was uncorrected as of the date of the termination, and it says the landlord hasn't taken reasonable steps. So as long as the landlord is making those reasonable steps to fix it, then
right,
this defense would not be eligible.
as of the date of the termination, that's good.
Yes.
I like that.
And so this is.
Now we know. Now we know.
This is consistent with the other section that auzes the tenant not to pay rent if there are violations.
Yeah.
That section also states that the landlord hasn't made some reasonable efforts to correct the.
Yeah, Debbie.
Okay, when you're not paying rent to the landlord, is this the place where they put it in, like, I guess they call it escrow? So like you could show the court, you know, like I have the money over here in my bank account, I can prove I have the money, but I'm not paying it because of these violations. Is that when this happens?
That's a separate thing, but
Yeah, I was gonna say, I don't think you need to do anything with the escrow. There's a section that says if there is a serious health, it doesn't use this exact term, but there's a section that says if there is a serious health and safety violation, then the tenant is not obligated to pay rent.
in other words, that's the habitability section.
Correct.
This is not the habitability section. This is a section that says if you've been sued and to be thrown out of an ejectment action, a defense is that it's not up to code, there's been a violation, and the landlord is not making any attempt to correct it.
Right, and so the tenant wouldn't have to prove that they've put the money in escrow anywhere. They're not obligated to pay, and this is saying that if the landlord then proceeds with an ejectment or a termination and an ejectment because you aren't paying, it's a defense to that ejectment to say there's this violation and you aren't taking any reasonable steps to cure it. That's why I'm not paying.
Yes,
Who defines reasonable? And would it be the court? Okay.
Okay. So the next change is going to be on the next page, page 14. I added this section. There was, I believe, a request from the Vermont State Housing Authority, under federal programs, including, their voucher programs, the termination periods, et cetera, are governed by federal rules. And so this section is just calling that out, that the termination section shall not be construed to apply to any program governed by federal law. Okay.
Karen, can you just, sorry, Ken.
please.
Does that include if you're receiving a voucher?
Yes, ma'am.
Okay,
Yeah, if you're receiving a voucher, then the landlord would have to comply with the federal rules associated with those programs.
okay.
Okay, the next change is on page 16, and this is just,
There are,
drafting technical amendment that we discussed yesterday, because there's two subsection A's here, so I'm striking one of them and going along with some more descriptive, so just highlighting that for you all. Our editors will probably slightly tweak or amend this. The next change is gonna be on the bottom of page 17, where we discuss the property that remains after eviction. And the only thing I've changed here is to further clean up this section, so the landlord may dispose of the personal property of the individual immediately upon the landlord being legally restored to possession of the dwelling unit. So I've removed the whichever is later, because you all wanted it to be immediately after. The next change is on the next page, where I actually amended the next section that wasn't previously here. This is saying that if the court stays the execution, so, the execution of the writ is being stayed for a certain period of time, presumably for the tenant to be able to move out, or for some other reason, the court has determined that the execution needs to be delayed, if you will, to the stay is. This section says that the landlord can dispose of the property 1 day after they're put into legal possession, so I just made that consistent immediately, so there's not a difference. Okay, now we're getting into the new ejectment process, and I changed this to just simply be Superior Court ejectment for non-payment or breach, because this process is limited to just those terminations.
right,
Okay. And then the next change is gonna be on page 19, where I'll change.
jury trial, yeah.
Yep, to just mirror what's currently there, allowing the individual right to a jury trial. Next change is gonna be all the way on page 22 regarding trespass.
Hold on a minute.
Yes, sir, telling me there.
Okay,
Okay, so I cleaned up the section at the top of this page, the 4868. So it's after you're legally restored, the plaintiff can issue the defendant an order against trespass for the entire premise subject to the ejectment action in accordance with, referencing back to the trespass section. Then what I've done is I've included the purpose statement that was in H 728. I don't know that it's necessary. I'm waiting on our judiciary team to get back to me, but I felt that it's probably best to indicate.
to be super
the
clear,
court,
yep,
to, provide that indication to the court system that this is the purpose behind these changes. And then in section 5, what I've done is I've cleaned this up a little bit. So I kept the structure of what's in 728. And then I just added this subdivision B. So it's notwithstanding subsection A or any provision of laws of contrary, the landlord of the dwelling unit may cause to be served an order against trespass to prohibit a tenant's invitees or licensees from trespassing in the dwelling unit if, and then I've just incorporated what was in my draft, which is the invitee or the licensee subject to the order has been ejected from the premises under 12 BSA chapter 169.
okay,
Okay. The next change is going to be in the confidentiality of the ejectment record. So I've cleaned this up a little bit based on our conversation and some of the edits that were requested. So there's not really a lot of amendments to the language. I've just struck some of the language and removed it. I've highlighted one of these things blue because I'm hoping to have a quick conversation with some external individuals about this sentence. Because there's two separate things as I understand them. There's confidentiality of something, and then there's kind of the concept of expungement.
right,
And so what this sentence is saying is
yeah,
the ejectment is deemed to have never happened.
I don't think we can say that.
And I agree, Mr. Chair, that's different than saying that it happened and it's just
I
confidential.
think that was a deliberate choice of the Judiciary Committee when they reviewed an earlier version of this last year. It didn't go out, but it was not sealed, it was not permanently expunged. It was confidential because the whole point is becomes when the landlord prevails, either by the landlord by default or by winning, it's the confidentiality disappears.
Right. And so I wanted to ask the Attorney General's office about this. And, you know, my recommendation is if you're wanting to simply keep them confidential, I would strike this sentence because I think it indicates a different legal consequence.
I think that as a de facto, as a default, you should strike it. I think that's pretty clear. You're right onto something. Also, I think it's very likely that the Judiciary Committee will, in one way or another, look at this. And I think this is a good place to start is by taking that out. Yes.
Is the point so that a new landlord can't see a history of whether there was,
Yeah, the point is, on the one hand, landlords rely as part of their check on a tenant. Did these people, were they evicted from any other prior unit? And the tenants are arguing, you know, a lot of times a case is begun just for reasons that I didn't do anything wrong. It's just a mistake, or I didn't pay rent, but then I cured it, or the landlord was wrong and lost the case. And what this is trying to do is to address both concerns by saying it's confidential, but once the judgment in favor of the landlord, it's not confidential anymore. So the landlord has access to that information.
I'm confused. So isn't everything public to begin with? And this is saying that the outcome,
No, this is saying that nothing is public with respect to a filing until the outcome.
okay,
So currently, an ejectment is public.
right,
The members of the public can go, it's a matter of public record.
okay,
What this language would say is that when an ejectment action is filed, it becomes confidential,
okay,
no longer open to the public. That confidentiality is only removed if the landlord prevails in the case. And it is a termination based on non-payment of rent or breach of the rental agreement. So if it's a termination based on any other reason, it would still remain confidential. So if it's a termination because the landlord is not renewing the lease,
Or condominiumizing.
Right,
Or
right.
anything.
and then they end up having to bring an ejectment action, that would remain confidential. But if it is a termination based on your non-payment of rent, or you're breaching the terms of the agreement, or acts of violence, those individual scenarios, if the landlord prevailed, they would remove the confidential nature of the records that would be available to the public.
now
There
I
is a
understand.
section here to answer your initial question that would prohibit reporting agencies, consumer reporting agencies from reporting the information that is confidential.
Okay.
So the only thing that would be reported under this language moving forward would be if the landlord prevailed because of non-payment or for breach, then.
Yes, Joe.
A question that goes for judiciary, but just curious. What happens if partway into the case, the person just leaves? Is
It's what?
there a judgment made for either at that point, if they just leave and
Yeah, just
it
default.
would be a
judgment.
judgment
Yeah.
made with the landlord at that point?
Yeah. Yes.
We've heard cases, or we've heard testimony that, you know, a tenant is being evicted, but part of their, you know, causing issues with other tenants. If it's confidential, are other tenants going to be able to testify if needed?
Yes.
It wouldn't prohibit the court from gathering whatever evidence the court needed.
Or the
It was just
attorney.
that
on the call.
information
Yeah.
that was provided to the court as part of the record would be confidential.
Gotcha, okay.
Can I just say
Yes.
one thing about that? We heard testimony last year also that very, very often they leave. They do leave so that this
Right.
doesn't happen and there's
If there's no ejectment filed,
there's
then
no
there's no,
judgment
then
filed.
this is not relevant. If there's an ejectment filed and then they leave, there's going to be a judgment in favor, a default judgment in favor.
Okay. have
Or the case could just be dismissed.
Dismissed.
If the landlord decides, it's not worth continuing to pursue because the tenant has vacated the premises.
And
You
it's,
ask for a dismissal of the case, just to.
and a dismissal of a case is assumed to be, okay, there was no problem.
Yes.
Okay.
Yes.
I don't know why this hasn't popped into my brain until this second.
It happens.
It does happen. In employment law, as HR, I hire somebody who's filled out an application and they said they have their master's degree in accounting. Turns out they never even went to school. I can then terminate them. Would it be considered a breach of a contract or a breach of a lease if a tenant lies on their application? I don't know what they would lie about, but it's like, if there is a question like, have you ever been evicted?
That's a good question, and I do not.
I would say I'll hazard an answer. Not in law,
Right, it's
only,
not a legal
only
document.
if your contract, the rental contract says that
You can
facts in
rent.
the application are correct.
Yeah, I think if you as a landlord had some sort of provision in there nullifying the contract if somebody was lying on the application, probably enforce that, but.
I think that's why they got rid of the question of like, do you have a felony on the very first application? Because it could have been 30 years ago and that would be, if you're just of the initial thing, people would just throw away your application even though.
Before you go to the yellow,
Yes, sir.
I want to clarify something here. Look at on that page.
20.
Yeah, I just want to clarify an earlier change. You see where it says who has access to this?
Yes, sir.
Where it says each party, the judge, court staff, and each attorney?
Yes, sir.
I'm just telling the group, I want to remind you guys, first draft of this bill had all kinds of additional people who had access. Anyone from legal aid, anyone
Right,
from
right.
legal services, et cetera. Judge Zone pointed out.
How do you
this is-
know who these
I
people?
mean, you're
Yeah.
asking the court to,
Yeah.
where are you from and will you prove it? And then I thought, and why? And I just realized this was exceptional, so we took it out.
And on that note, Mr. Chair, on the sub D here, I removed a lot of language because it also had the court. This was the language, upon motion and subject to a balancing of interests for and against disclosure, the court could make confidential ejectment records available to requesting parties for scholarly, educational, journalistic, or government purposes.
And Judge
All of
Zone
that.
called that, I think he referred to it as wide open.
Yeah.
So this would limit it, Mr. Chair, as you mentioned, to just the parties, just the court system, the attorneys representing the parties, and then there is in the sub B, they can make the confidential records available to any person with a valid court order authorizing access to the record. Okay, so the next change. I think we're gonna go all the way down to the appropriations section. Where I've added in the 600,000.
33.
So the sum of 600,000 to the Department of Children, for children and families to be granted to community action agencies to be used to support liaison work with landlords and tenants. That is very vague language. So you can keep it vague, or if you all want to further clarify, I was reviewing some of the materials that were given. I really wasn't able to ascertain whether this was like a current program with a proper name.
Right, I think
So-
just assume that if this stays in, when we will give, we just couldn't get more information fast enough. We'll just give it the information to appropriations.
You don't want to say like cap agencies or.
So
It says community action
agencies.
agencies.
There was also
Oh, it's-
within that request, a distribution of the funds of 200,000 to one in particular. I didn't include that because I was just trying to get it in.
Yeah. Right.
But if you wanted to make.
I
that
think that
distinction-
we can make that clear. I do want to comment on this appropriation section, if I might. I'm somewhat torn. to be honest. I feel like we should leave this stuff in, but with an understand. On the one hand, we all know there's no money. I intend to tell, and I have to testify this afternoon as chair on our letter. Remember our letter? I intend to tell them that two things. First of all, I intend to tell them that 3A, 1 million to the Vermont State Housing Authority for Rent Assistance Fund, we put that in tier 1 of our letter. And I intend to say that is a priority. And the reason it's a priority is that it addresses homelessness directly in the landlord tenant context. And everyone I've talked to has said that program, it could be loosened up a little, it could be worked on. And I have heard from the director of the housing authority that they're doing that. But everyone has told me that it's an excellent program and really important. It's running out of money, and I'm going to indicate that's a priority.
Can I say something about that?
Yeah, go ahead.
I support that, especially given the context of what we're doing to the landlord tenant.
Yes,
Like if we're shortening evictions and we're putting frameworks around like, I have plans for my place, blah, blah, blah. Like we've heard that evictions are 80% or whatever the figure was because of running out of money.
not
And
paying
so
the rent,
this,
75% in Burlington, yes.
right. And so I think that we've also heard how easy it is to fall in. So,
Right.
Yeah.
So actually, Lenora sort of said half of what I was going to say.
Oops.
Well, no. In other words, I started off by saying we're on appropriations here. I'm just saying I'm ambivalent. What's going to happen in appropriations is they're going to put right up at the top, for each of these, this is what they do. They'll put to the extent funds are available, period. They do that with every bill, okay? In other words, they don't strip out the money. They just put to the extent funds are available in the budget. Then they do all the trade-offs when they make the budget. I think personally, my own opinion is that money is so tight this year that many of these things will either not make it into the budget or in very reduced form. Nonetheless, here's what I'm planning, absent contrary instruction from my committee. I am planning to say to them pretty much what Lenora said, that the essence of the bill is to try to seek balance. And one of the things that is essential to the landlord community and may help tenants in some ways, but it's basically for the full financial functioning of the rental sector is a shortened eviction process for people who really have to get out. And that the price of that, let's just be honest, the price of that is the possibility of an increase in evictions. And some of those are going to be homeless. So we're talking about potential increase in homelessness. One way we deal with that is by having more rental units, by encouraging landlords, if we're making life easier for them, to invest and create more rental units.
And more housing,
And more housing.
billion.
But on the other side, I feel that it's important that we try to improve or maintain the safety net for homeless people. And that's what this money is about.
Mhm.
So even though I know that they aren't going to be able to prove everything, I think that I have to remind them it's important. And that's why that's in here. I just want to say for myself, that's why I feel strongly that we need to say these things, regardless of whether we think they'll do it. And we have to fight for it. Yes.
I think it's important also to remind them that this program has, like, the candidates for it are people that have been paying, like,
Right.
these are exactly the people that landlords want to be renting in their properties and with a little bit of help could get past,
Get past it.
you know,
And
the,
that helps landlords as well. And also I will add that the alternative is the motel program, which is very expensive
That costs way more money,
and splits
Yes.
families up.
right? I
Is there any other?
not on appropriation, but I had to step up for a call, but can we look at something on page 7? The termination of tenancy notice section on page 7. I'm shuffling around. Oh, not you. I would, and again, this is my wishes, not, and I know I'm the one who's like, let's get it done, but I have the,
Well, we have counsel
we
here.
have counsel here who needs to be here for this. I think that myself and a couple other members on the committee had discussed yesterday, I believe, about something from the network language around survivors and people who were, if there was an eviction, not having people who are, I don't know, with not having those folks,
right, who the victim,
right, the
like if you're
victim,
trying to get out the perpetrator,
right,
but the victim was there
unintended
too.
consequences related to eviction for, and I believe the network had sent in, did they have language in their memo or no?
Are we talking about the eviction for the dangerous tenant? Or the,
Yes.
the dangerous tenant?
Right.
Yeah, and so you want to make sure that.
I want to
the
make
victim
sure
is
that
not evicted.
victims are not harmed in any way. I would like to make sure that,
So this is not on that page. Where is it? It's,
I was talking about where it would go.
yeah, I know. I'm just trying to get to the right page. It's 2A at the top of page 8. Where termination is based on acts of violence, the set landmark terminate the tenancy.
Right.
Okay. So the question is, we want to, the real question you're asking, you're trying to prevent a situation where the victim is.
Yeah.
Is
Protected.
evicted. Yeah. Joe?
I guess, I feel like I definitely saw that letter that came through, but without seeing it in any form here.
Yeah, I don't know.
It seems really hard to try to get to that, because number one, I think you fall, not that I I totally don't want them kicked out because, yeah.
Well,
But it's really hard to get to like the victim of, because then you fall into the same thing we did years ago with another bill. It's like, well, you're not a victim yet because they haven't been charged in court, and you know, I'm gonna come through the whole process. So now they're kind of a potential victim of. And then were they a survivor of domestic violence 30 years ago? Or is it like something that's happening now?
Well, it's as a result of this, whatever issue.
But it was just like the way to word it. It didn't jump out to me as like, oh, that's clear. It's like, how do you? spell
Okay, well,
that
here's
out?
the question.
Yeah.
We're telling him
I
what
don't
we're
want
sad
to-
about,
I
and he
don't know
has
how
to
you
make it
do.
into language.
I want to propose a possibility, but I'm not going to advocate it. I'm just being
Yeah, and
a
I just wanted
wordsmith here.
to
Well,
flag it.
okay, well, I'm asking a question. We do have a remedy. Hear me out now. We have a remedy for the drug dealer who isn't a tenant, who lands on the tenant and says, at the point of a gun or a hypodermic needle, you're letting me stay here, right?
Mhm.
And that remedy is that enhanced trespass.
Visitor trespass.
Okay,
Mm.
all right. So if I want to get the tenant out, excuse me, if I want to get the offending person out and the offending person is not the tenant is the victim, I have my remedy in trespass. So this really is aimed at, well, gee, what if it isn't the drug dealer who's landed on them? What if it's the tenant?
One of several
Yeah,
tenants.
Right.
So
Yeah.
what I'm wondering is it overbroad and dangerous and harmful to the landlord, or is it a solution if we were to read when termination is based on
Acts of violence.
acts by the tenant, which are acts of violence, damage, or any other activity. You see what I'm saying?
Yeah,
I think the question is what happens if it's two tenants in one unit?
Right.
So if it's, you
yeah,
have.
and you're both on the lease.
Because right now we're saying the tenancy, the whole tenancy
Right.
ends.
Okay,
I think the option
I can't, I'm,
Sadia has her hand up.
hey, Saudia?
Thanks. Yeah, so here's the thing. And I was trying to save my comments for discussion, but I feel like if I do that, it's just going to be too late.
Yeah, go
And
ahead.
and ultimately what I've been trying to say this whole time, it's not that I don't agree with what you're trying to do. What the problem here is you're trying to do too much at the same simultaneously in this bill. And because Bartley just stated, going over everyone's head in the room. And for transparency, like I don't know how many people in the room at the table who are making the decisions on this are currently renters or have rented in the past 5 to 10 years. Because as we have heard, the rental system has changed over the course of those years. I will explicitly say on the record, my most recent bout of homelessness and eviction was 2018 when I went through the process. Okay, so I will say that, but that's not what I'm talking about here. I'm talking about here is the violence. My first apartment, my first bout with homelessness and becoming homeless as a result of tenancy was when I was 17 years old, living with a partner in my apartment that my name was on the lease and I paid the rent and security deposit. And I was abused. I was put through a wall. My 4'11", 98-pound body was put through a wall. And my neighbors heard me screaming for help and called the police. And the police came and told me they were taking me to. Do you know who had to move out of that apartment?
Right.
Do you know who had out of that apartment? Who had to move? Me. I had to pack up all my belongings. I had to leave my place, my home, to protect my life and my safety. So what we're doing here, when we're saying who we are protecting, we should be doing these things in isolation to make sure we're getting to what we're doing. We can't say, oh, we can't do anything about it because people's lives are at stake. Because if we can't do anything about it, then who will? That is why we're here. We're here to fix the problems, not with a broad stroking brush. Sorry, if we're gonna address it, it has to be addressed. And there is a way, there is language, and we don't have time really. And if we want to say that we have to not move forward with this bill to get to the point, then so be it. I hate to see that happen because there is some good things in this bill. I'm not saying it's all bad, but there is a lot of harm that will come from this bill as well. Sorry.
Thank you, Saudia. Debbie?
Well, I
Then
just want to
Tom.
make sure I understand the situation. Abusive situation, the police get called, the police come. And I thought the way the laws were is that the victim doesn't even have a say anymore. The abuser is removed.
I think that what Saudi is getting to, and actually the issue we're wrestling with is not the criminal part of whatever activity, not the whole criminal side, but what happens in a situation where, and Chris, I might ask you to comment on this. Maybe there's nothing we can do, and some of us are feeling like, gosh, maybe it's not amenable to change. But the situation, I just want to lay it out, is where it's really not the tenant that's the problem. It's member of the tenant's family, like, or the tenant's, a partner or a drug dealer or somebody that's landed on them. And the question is there any way to protect the tenant in that situation as opposed to others? And I don't know that there is, but I just want to be clear about what Saudi is saying and what you're saying. Chris, do you have anything to add to this at all?
If they are on the lease, it's thorny, difficult.
Mm.
Yeah, if they're on the lease,
On the lease, if there are people on the lease, it's thorny, it's difficult. I think the.
speak up just a little.
The provision of the no trespass in this bill is very helpful.
Okay.
But that doesn't help if they're on the lease. The courts have, and I think Judge Zone mentioned this, the courts have the ability to have conditions of release when someone is arrested. And that one of those conditions could be that they're not allowed to go back to the apartment.
Hmm.
The
Under
problem-
current law.
in current law. Problem in practice is that then you have to rely on the police report to prove that they're a danger to the other tenants or the rest of the building. And so it's just not foolproof.
What's the matter with relying on the police report? Sorry.
The police reports don't have enough information for the state's attorney to actually make the case. The condition of release is that they can't go back to the apartment. So there's just not enough detail oftentimes in the police reports. And so it's the education with each individual police department that needs to happen.
If
So
they're-
how about this?
If they're not on the lease, if they're on the lease, you said it's difficult because you can only,
They have a right to go back.
or you evict, you can't evict one signatory on the lease and not, you evict not everybody on the lease, right? I see. Yes, Tom.
I think the enhanced trespass creates the opportunity to terminate the lease, apply the enhanced trespass to the perpetrator and write up a new lease for the remainder of the tenants. It's an option. I don't know how kind of whether that's
I
doable,
think
practical, but
it would take months.
How about this?
It may not be practical.
How about this?
then
For the sake of everyone's lives and what we're doing, I see two options moving forward. One, I'm thinking that if we can't come up with, I'm gonna try to get some language that might be amenable. But if that's not, then I'm committed to working with the network to work on it in the next chamber.
yeah.
And so I am gonna try to get a language piece. You don't have to do anything. I'm gonna try to get a language piece before we come back. And if it does not get agreed upon and it's too much to deal with and people don't find that amenable, then I'm gonna commit to working with the next chamber to make sure that the network has time to present and take the testimony on survivor and this type of language. Does that sound like a good plan for people?
Yeah, and I would, oh, sorry.
Well, you both raised your hand at the same time, and I'm going to go with Lenora, you're first.
Before.
Yes, we have to come up with a remedy. I think we need to write legislation that allows a name to be removed from the lease
Okay.
rather than canceling the whole lease. There's got to be a simpler way to, we're gonna have to create a way for a tenant victim to be protected.
I think that might have to be done with this in the Senate.
Lenora?
Yeah, I'm just encouraging conversations with our judiciary folks too, because I think that that's gonna end up in their hands, in their lap at some point. And so-
Right, that may be a suggestion when after they do their flyby, they may have that too. So I'm gonna get language in the next-ish time.
Yep.
From the network, and I'll share it with everyone. And if it seems like it's not a easy just thing to add into our bill, then perhaps when it goes to judiciary, they'll make a suggestion. Given that that's more of their wheelhouse and they deal with the network stuff a lot. And then if that doesn't make it in, then I will commit myself to making sure that our Senate counterparts hear from the network on this piece and write a letter myself or with others. Does that seem good?
Seems fair to me, yeah.
Okay.
So to sum up, what I'm hearing is that there seems to be a general recognition that although this section is important, I mean, this section was drafted, it's a major part of the bill. It was drafted in response to a lot of testimony we heard that this is addressing a major problem confronting landlords. It is not without, what I'm hearing is that there are situations, they may not be the majority of the situations, but there are situations where the tools that are available are not as good as they could be, and we have to make them better. And we just don't quite yet know how to do that. And
Right.
so we're gonna have to do it either in another committee,
Yeah.
via another committee or otherwise.
And as Sadia mentioned, why are we here if we're not here to make things better for everyone? And this is a glaring piece of policy that we are working on and doing great things, but it's not closed forever. And so anyway, so I'll let everyone know when I receive the language. And if it doesn't work, then we'll work on it in another chamber. Thank you, for hanging in there with as things go on. Joe had his.
Joe,
Separate from that, but same area of the bill.
yeah, where are you?
So page 7, I'm trying,
Not until 10:30, right?
11:30.
Oh.
11:30, okay, all right.
could you help me understand, Cameron? The 10-day termination for non-payment of rent in coordination with the late payment of breach of the rental agreement. And then,
Like we want
yeah,
to
then on
highlight.
the page 8, it references the 10 days again. So they're not, what I'm getting is, if they're more than 10 days late on rent, you can terminate them for that.
Generally, yes, sir. I
Okay.
think the language
Yes.
would allow that, yes.
Day 12, you can just say, we're done. You can send them a
You can give
termination notice.
Right.
You give them their termination notice.
Mhm.
And then they have 10 days to pay it after that.
So if you're doing it for non-payment of rent.
Yeah.
Your agreement, whether in writing or verbal, says rent is due on X day. And it's first. Again, as I've mentioned, there's a separate section that says you do not have to demand it, it's due on that day.
Yes.
If you. I see nothing in the statute that would prevent you if 10 days later they hadn't paid, it's the first month. Or presumably the second month, you got the first month's rent when they moved in, so maybe it's the second month.
Yeah.
The statute would authorize you to. Provide them a termination notice on day 12, as you mentioned. Keep in mind, you have to provide the notice, right? So. If you're hand delivering it to them.
Okay.
And then the notice period is currently 14 days, so you would say the rent is terminating 14 days from now.
The tenancy,
Right. This is proposing to reduce that to 10.
Yeah.
The section also says if the person pays rent during that period, the termination notice period, it kind of cancels the termination.
So you cannot,
So you would not be able to move forward at that point.
but now below, if that process plays out 3 times, now you can.
Yes.
right?
So it's
Another-
saying that if you 3 times you've paid late, now you're not gonna move forward due to non-payment of rent. You're moving forward because you're breaching the terms of the rental agreement.
Right.
Which has a separate notice period. It has a 21-day notice period, so. You'd have to provide them more notice, but they wouldn't be able to necessarily cure that notice, you would be able to move forward regardless of whether they paid you or not.
That's an important point.
So after that one,
Yeah,
they can't.
They can't- this is-
Hearing.
yeah, this is an important change in this law. One, by the way, that is, appears somewhat hyper-technical, but it's important to note. In prior law, it's really not clear. This is not, it's not clear what happens to try to help the situation where someone is late once, but then they keep being late. What do you do? And our attempt here is try to make it absolutely clear that if this happens, if you have a repeat offender where they're repeatedly late, they can't just say on day 12 yet again, oh, here's the rent again. At that point, they have violated the terms of the lease and you can evict them and the eviction stands.
And I will just comment, because you asked about the separate 10 days on page 8.
So I'm trying to tie that one into like how we decide that it's late, because that says it's not.
Right, and so that's saying that for purposes of the termination notice period, so to be able to terminate someone, to be able to terminate their rental agreement due to repeated late payment of rent, the late payment has to be
More than 10 days after it's due.
more than 10 days after it's due. So if it's 9 days after it's due, it might
Repeatedly.
be late,
But this 3 strike thing doesn't work.
but you wouldn't be able to use that as justification under that section.
Yeah, the 3 strikes is a good way to put it. Right now, the strike is defined as 10 days late in this draft. Debbie,
I just want it on record that if we're giving 5 days for mailing, I would like to go to the 3-day. Because.
Yeah,
When
go ahead.
you look at what you have, when you do 10 days plus 5, right now we have 14 days plus 3
Mhm.
for mailing. We haven't done anything. And this would bring us almost back in line with the 7 days that you had in your original bill.
Well, I just want to say that is a committee decision. I do not have any strong feelings on 5. I'm happy to make it 3. It's up to the committee. I mean, my feeling, I guess, all right. As chair, I think this is a committee decision. I think we should decide what to put in the strip, okay? I think it's up to us. I want to say, I want the notice to be effective. At the same time, I don't want it to take forever. Yes, sir.
I'm sorry to interrupt you. May I propose something for myself?
Please.
I have 2 edits here. May I go make them and get this into the editing process? If you are feeling like you're at a position where you're not going to make substantial amendments, if you're amending a day, that's easy. I can do it here and you can vote it out. Those are easy, but I do want to get it to the process. I'm just thinking if I could go do that while you all continue your discussion, then I can get it in. the
Okay, if
editing
it's
process.
edited and we do not have consensus and don't want to vote it out, then it can be edited to get changed and edited again.
And that's what I'm saying, and once I get it edited, if I get it back and you're just changing a day, we don't want it to be 10 days, we want it to be 7 days. Like, I don't need to have it edited for that purpose again. So I can make those edits on the fly and then you can vote it this afternoon if that's what you're aiming for. Because there are some substantive changes here, I want to have those edited and I just want to get it into the hopper as soon as possible if you're looking for a possible vote today.
We are.
So
What, Debbie, you got your hand up?
I have my hand up because I think on paper, show cause looks great, but in reality, it doesn't fly. We've been through it. And I think we need to also, we can keep that in there, but we have to have no cause.
I think that's a policy issue that we should deal with on that level. I mean, I don't think that's a drafting issue. I think it's a real policy issue.
I
Okay,
have
yes.
some drafting issues that just came up, on page, when we were talking about the does not apply, page 14. section M on line 13 that says this section shall not be construed to apply to any programs governed by federal law. I'm getting advice that it should say shall not conflict with any programs, just
No, you don't.
because some of the
You can't
things.
say conflict, because it would read the section shall not be construed to,
Conflict with any,
they do conflict. That's the thing. They're intended to conflict because they're entirely different. Because there are termination periods that govern federal programs that have different timelines than what you've put in here.
yeah,
So I don't want it to say the section shall not be construed to conflict with any programs governed by federal law, because the section does conflict with programs governed by federal law.
We want to go the next step and say, if it conflicts with federal law, it doesn't apply.
Right.
Chris, do you have some comment on this?
There's a lot in this whole section that,
that you would want to apply.
that we would want to have it apply to program. By federal law.
So I would then say it this way. You can either tell me which ones you want specifically, and I could call them out individually, but I will also highlight for the committee, I don't legally think you need this language anyway, because there's nothing that the state is going to do to preempt those federal program requirements.
Yeah.
So like I would articulate it to you this way, this doesn't exist in the section, and the federal law controls.
What page are we on? I'm sorry.
Page 14,
14,
subsection L.
that M highlight.
Yeah.
So
That says,
It doesn't currently
so
exist.
we're stating the obvious.
I think it can be helpful to signal to the public.
Uh-huh.
Well,
So-
what if it said,
So I don't think it's harmful, but I don't think it's necessary, because these programs are currently governed under the federal program requirements currently as it is, and there's nothing you're gonna change in the state law that's gonna change that, because you
Right.
can't preempt the federal. program.
well, but I think you've made the case for taking it out. Would seem to me the choice is either take it out or write it to say no provision of this section which conflicts with federal law shall apply.
If you only want the ones that conflict, and that's
Yes.
where
That's what, yes.
I don't know if that's what they're saying, so I think that would
I
be a
think-
question if that's what they're saying.
I think, Chris, what you're saying is there are sections that you would like to apply.
Yes.
But so let me restate it in the opposite though, which is what I need to know. Are
We
you
can't-
only wanting the sections that conflict not to apply? So if it doesn't conflict, you want it to apply? And if that is the case, I would say, but then they don't conflict. So
I think that this is a puzzle. Take it out. Take it out and we'll deal with it. And
I'm happy to keep working on it.
yeah, we'll
So that
keep
was
working on
one
it.
flag.
Yeah, right.
And
Thank
then
you.
the other one, I just wondered whether we need to specify the credit report that it be a soft check, like do we? I know that folks were very worried about if I'm getting a lot of, and
But the problem is we have to define that term. It's not a defined term. We'd have to define the term. I'm just not sure. Yes,
Peter Tucker for the Vermont Association of Realtors. You know, I heard the discussion on soft check, and I had a conversation with
Chris,
Delia from the bankers. If the tenant gets their credit report, that is a soft pull. But if the landlord pulls the credit check, that is not a soft pull. I think first time, not that big a deal, but think about a land or a tenant who, you know, goes to one landlord and doesn't end up getting the apartment. 91 days goes by and, the next landlord says, hey, I've got to get a fresh credit report. Those sequential, maybe the first one doesn't really ding their credit, but if they're pulling in a short period, multiple in a short period of time, then it would. I'm not a banker or an expert on this, but I talked with Chris yesterday and heard that, and I wanted to make sure it was clarified for the committee.
I think that the 90 days was our best effort there. In other words,
Sure.
it means
Right.
the tenant only has to pull it once.
And
in
this
90
is,
days.
and this is something that I've flagged again for myself to follow up on, and I've met with them about it. I will be looking for those unintended consequences
What do you mean?
as we move through the building. It's something that is not good, that I don't like. Right?
Can we make the validity last longer so that there are fewer? I mean, we're putting in here that we would like the person to be able to use the copy of their credit check
Right.
when applying to other places if the other landlord is requiring a background or credit check. The other thing is that I can't tell. I mean, I think we're pretty familiar with credit checks services, but I don't know what a background check entails. Whether we need to also, like, what,
Background check.
yeah, you would know.
Yeah, so what happens is depending on the software being used or depending on the industry, because they're all very different. Somebody provides their first name, last name, any aliases they've ever had. So if you've been married, so my alias is Ashley Strong. My birth date and my social security, and they go either things say, yep, you're good, or
Flag or
something pops up.
Yeah.
And like, I don't know if there's any software that says, hey, you shouldn't rent to this person, or you shouldn't hire this person. It's usually up to the discretion of the landlord. Just the same as for an employer.
But so I guess,
Like, it's not
what I'm
gonna,
saying is that the fuzziness in saying, I thought we had delineated between charging for a credit check versus a background check, because a background check, now suddenly it's creeping into an application fee, because it could be like, I'm using my staff time to call places. I'm using my, like, I don't know what I feel like we had distinguished between the two.
I thought we had said
before.
actual costs.
We said actual cost. I mean, I think, I guess my
Do
view,
you know what
yes,
I'm
I
saying?
do, and I think that the language says it's the actual cost of the credit check, not the actual cost of performing the credit check.
What's the difference?
Whether or not you're billing them for the time that you spent doing it.
Right, like, are you gonna bill for the utilities and the time and the staffing and the,
Yeah.
So
internet?
actually, like, when you do the background / credit check, isn't it going out of state looking for felonies and evictions?
It depends. So, I mean, most of my experience is in employment, but some will just do just Vermont. Others are, state,
National.
yeah, so, I mean, a good example is for teachers, Title 16, BCIC, that is a national. But, there are softwares that can do like an interim where it's just Vermont. So like, it really depends on what somebody's going to use.
So the companies that we've used, you get a choice, like 3 states or 5 states, and what comes back is any felonies and any evictions. And of course, whether there's a sexual predator or something like that.
I guess I would like to release counsel at this point, because to pursue this, which we may have to, is something that would require defining something that has never been defined in law, the term credit check. And I don't see an easy, just like add a word here or a sentence there to this problem, this fear that you're describing, that we've opened a door that for landlords to charge all kinds of things beyond actual cost. So I'd like to release him at least to just get this going and edit it.
So I have 3 edits that I'm making. The clarification that if a landlord runs the credit check, they have to provide a copy to the applicant. And then I have removing 2 things. One is the reference to the federal housing program. The in the confidential ejectment records section that it has never to have occurred. I will comment to this and very quickly in response to that discussion we were having, you have added in very clearly that a violation of that section regarding the application fees would be an unfair practice in commerce. So
Right.
the AG's office could issue, guidance or rules associated with that. And if you saw, or if tenants saw repeated possible offenses from a landlord who is charging some sort of excessive fee that wasn't actual cost, the AG's office would be able to investigate that. So I think that will be helpful in clarifying that section, that the AG can then begin to further articulate what are violations of that section.
I
But
think that's great.
I don't think that necessarily alleviates the concern that's been raised, but I think it's at least helpful.
Take off, but
I think were you going, he was maybe going through the 3 edits.
No, that was it. I went to the 3.
Okay.
yeah, I'm not ordering out of the room.
Get out.
But I do think it would be good if you could, when that's done, come back. Because I have a feeling during discussion, we're gonna take a break now for
Okay.
15 minutes, and then during discussion, there may be legal issues.
This is what I'm gonna do. I'm gonna go make these edits, get it in the process. I'm gonna try to be back here at a minimum, maybe 11. I do have to step out at 11:30, but I will at least be here in case you all have questions.
Are you going to,
I'm
We'd like to
joining
know
you.
your
You're joining
whereabouts.
oh, that's right. We have a tracker on you.
Government operations is where.
Oh, I believe someone else is going there
But I
today.
asked them to have it edited as quickly as possible.
Okay.
So you.
Yeah, we were
know
gonna track
As
you.
soon as I get it back.
Okay, great. Okay.
Okay.
Let's take 10 minutes. Let's come back here at 11:45, please, and we'll have discussion. We can